In Arizona, fair housing principles are not only moral obligations, but also legal mandates that extend deeply into the realm of advertising. Every piece of real estate advertising, whether a printed flyer, an online listing, a social media post, or a billboard, must comply with both federal and state fair housing laws, ensuring that no consumer is excluded, discouraged, or misled due to protected characteristics. The prohibition against discrimination in real estate advertising is enforced through the Federal Fair Housing Act, 42 U.S.C. 31, Paragraph 3601 to 3619. The Arizona Civil Rights Act, ARS Section 41-1491 each seek, and the Standard of Practice 10-5 and 10-3. These laws collectively ensure that every person has equal access to housing opportunities and that licensees represent properties without bias, prejudice, or exclusionary language. Real estate licensees must understand that discriminatory advertising is not limited to overtly racist or exclusionary statements. Discrimination can occur through subtle language, imagery, or even the choice of marketing platforms. Under R4-28-502C, all advertising must be truthful and not misleading, and it must also comply with fair housing laws by avoiding any words, phrases, or visual cues that suggest a preference, limitation, or discrimination based on protected characteristics. These include race, color, religion, sex, disability, familial status, national origin, and under Arizona law, ancestry and sexual orientation in certain municipalities, such as Phoenix, Tucson, and Tempe. Scenario-based examples demonstrate how these laws are applied in practice. Consider an agent who creates a flyer for a new subdivision that describes it as a perfect neighborhood for young professionals. While the statement may appear harmless, it can imply exclusion of older adults or families with children, which would violate the prohibition on discrimination based on age or familial status. Similarly, a listing that says walking distance to church or ideal for Christian families implies religious preference, which is strictly prohibited under 42 U.S.C. Section 3604, subsection C, and Arizona Revised Statutes, Section 41-1491.22. Even photographs can communicate discriminatory messages if they depict only one demographic group, implying that others are not welcome. Another common violation arises when licensees use language suggesting restrictions or preferences that align with discriminatory stereotypes. For instance, phrases like exclusive neighborhood, safe for single women, or no children allowed directly violate fair housing advertising standards. The U.S. Department of Housing and Urban Development, HUD, has made clear that even if discriminatory intent is absent, the use of such language can still constitute a violation because it has the effect of discouraging certain groups from applying. In the case A.U.D. versus Gruen, 1994, an agent's use of the phrase ideal for young couples was deemed discriminatory because it discouraged families with children from considering the property, even though the agent claimed the intent was simply to highlight affordability. Arizona's laws go further by requiring that all real estate advertising include equal opportunity principles. Although there is no legal requirement to include the Equal Housing Opportunity logo or slogan, doing so is strongly encouraged by both HUD and ADRE as evidence of compliance and commitment to fair housing. For example, a brokerage that consistently includes the Equal Housing logo on all listings and digital marketing materials demonstrates proactive adherence to ARS Section 41-149, which prohibits any statement, advertisement, or publication that indicates discrimination or limitation based on protected characteristics. In scenario-based application, let's consider a real-world case. A licensee creates a social media ad stating, "Cozy condo community for singles and retirees only," This language explicitly excludes families with children and therefore violates both federal and state fair housing laws. If reported to the ADRE or the Arizona Attorney General's office, the licensee and the broker could face disciplinary actions, including fines, suspension, or mandatory fair housing training. Similarly, an agent who uses social media targeting tools to exclude certain demographics, such as setting Facebook ads to show only to users of specific ethnic backgrounds or income levels, can also be found in violation of fair housing advertising laws. In 2019, HUD filed charges against several companies for allowing such targeted digital advertising, setting a modern precedent that fair housing compliance extends to online marketing algorithms. Misleading or discriminatory advertising may also expose a broker to liability, even if the broker did not personally create the ad. Under R 4-28-502G, the designated broker has a duty to supervise all advertising produced by their licensees. If a discriminatory advertisement is published, the broker can be disciplined for failure to supervise, while the agent can face direct penalties for violating fair housing and advertising laws. The ADRE Commissioner has the authority under ARS Section 322153 to suspend, revoke, or deny license renewal for any act of discrimination in advertising. The consequences of discriminatory advertising reach beyond regulatory discipline. They can also result in civil lawsuits. Victims of discrimination may file complaints with the Arizona Attorney General's Civil Rights Division or HUD. If the investigation substantiates the claim, the violator may be ordered to pay damages, civil penalties, and attorney's fees. The reputational harm to both the agent and brokerage can be long-lasting, as fair housing violations are a matter of public record. The safest and most ethical approach to real estate advertising is to adopt inclusive, factual, and neutral language that focuses on the property itself, rather than the people who may live there. Instead of describing a home as great for families, agents can use phrases like spacious layout with multiple bedrooms. Instead of walk to temple or church, use near community centers. Licensees should be vigilant in reviewing all advertising to ensure it communicates opportunity rather than restriction, inclusion rather than exclusion. Review summary. All real estate advertising must comply with federal and state fair housing laws, including 42 U.S.C. Section 3604C, ARS Section 41149.22, and R4-28-502, advertising that expresses or implies a preference, limitation, or discrimination based on protected characteristics is illegal. Even unintentional or subtle language that suggests exclusivity can result in violations. Both the agent who creates the ad and the broker who supervises it are responsible for ensuring compliance. The ADRE and the Arizona Attorney General's Civil Rights Division have authority to investigate and discipline discriminatory advertising practices. Discussion. Why is it important to avoid even subtle language that implies preference or exclusion in advertising? Answer. Because fair housing laws prohibit both intentional and unintentional discrimination, and even subtle language can discourage certain groups from seeking housing opportunities, violating 42 U.S.C. Section 3604C. What are examples of acceptable alternatives to potentially discriminatory language? Answer. Instead of saying perfect for young couples, use affordable with an open floor plan. Instead of no children allowed, focus on factual property features such as one-bedroom loft design. What agency enforces fair housing advertising laws in Arizona? Answer. The Arizona Attorney General's Civil Rights Division enforces the Arizona Civil Rights Act, while the ADRE oversees compliance among licensed professionals. Closing remarks. Fair housing compliance in advertising is not merely a legal requirement. It is a reflection of a real estate professional's integrity and commitment to equality. Every advertisement must embody the values of inclusion, opportunity, and respect for diversity. By ensuring that all communications are neutral, factual, and inclusive, licensees uphold both the letter and spirit of Arizona and federal fair housing laws, contributing to a more just and equitable real estate market for all.